Hi, everyone. It's Grant Abbott speaking, and welcome to this, what I believe is a really fundamental and an important session. We're going to be looking at, although I've said it's upgrading a discretionary trust deed without a resettlement, but we're also going to be looking at other trusts such as self-managed super funds, testamentary trusts, unit trusts. So any trust that we're going to be looking at today, and particularly the law around it and what is and what is not a resettlement, effectively that will apply to all of those different trusts, a child maintenance trust, a spousal support trust, family protection trust. Look, it just goes on. And it's, for me, it's very exciting because when we have a look at it, and I'll come back to this, when we have a look at it, for such a long time, we've been told by lawyers, particularly when it comes around to self-managed, child maintenance, discretionary or testamentary trust, that if you make a change to the actual trust deed, and I have seen lawyers give advice that if you change the beneficiaries, if you change the appointor, and provided, and I'm assuming there it's actually done in accordance with the existing deed, of course, that provided it's a legally valid change, that in effect there may be dangers of a resettlement. Now, in short, a resettlement essentially is where the old trust dies because there's been such a fundamental change in the trust terms and conditions, and a new trust starts up. So as you can imagine, we call it a resettlement, but effectively what it means is taking the assets from one trust, the old trust that's died, and putting it into a new trust, resettling those assets, which obviously creates capital gains tax and stamp duty issues. So for many years, and even my legal partner, Tony, probably even 6 months ago, was still saying, look, there's a resettlement, there could be a resettlement. And I must admit, even on our website, we talk about a couple of those issues. So I need to go through that because we have done quite a lot of work on this to ensure that as best as possible, when I mean as best as possible, that we give you the tools to ensure that there is no resettlement. And if it's, and I'll be going through the guidelines there, the tram tracks where you guys can do it quite easily. And then more importantly, where we've got an extremely old deed, like a 1970s deed, a 1980s deed that's been varied or upgraded half a dozen times, why you might in those instances provide it to Abbott-Family to do that upgrade if it's really important. But for honestly, the run-of-the-mill, most 95% of the discretionary trust deeds that I review effectively can be upgraded, and there is no resettlement, which is a fairly important point. And of course, where we have to look, and I think this is really important for us, is obviously Bamford versus the Federal Commission of Taxation, 2010 in the High Court, enabled, and it was a fantastic case for all of us because it's been one of those issues that have been on the fence for probably since I was doing tax, even before that, whether we could stream different forms of income such as foreign source income, franked dividend income, capital gains, whether we could stream those out to individuals. And we never really knew what was going on. The actual case, Bamford dealt with Sanitarium, which was an exempt charity. So obviously when we streamed to those, there was quite significant benefits there. But the Commissioner obviously tried to knock it on the head, but the High Court had its way. And suddenly something that we'd all been warned against for such a long time, for 20, 30 years, that you can't stream, accounting income means this, taxable income or net income means that. Suddenly we had the highest court in the land provide us with some definitive guidance. And of course, once that was out, the only way to change it was to obviously change the laws. The tax office went along with it, and really from that perspective is that we needed, post that, is really all deeds needed to be upgraded. Much the same way if I go back to 1998 when the Commission of Taxation took over effectively from the 1st of July 1999, the regulation of self-managed super funds, and the term excluded fund, which was the original self-managed super fund, was then replaced by self-managed super fund, meant that virtually all SMSFs needed to be upgraded. And again, the issue was, is there a resettlement, because there was a fundamental change. So a lot of people haven't gone through the process of upgrading their older client deeds, which means that pre-2010, there probably hasn't been any income streaming in them. And that's generally been for fear of resettlement. But the Commissioner of Taxation has come along to save us on his shiny white horse, his shiny white unicorn. Before I get there though, I just want to give a plug for our Master Strategy Day, which is happening on the 26th of March. Most of you are strategist members, so you can access this straight off our website. You'll see on the top pages, we'll go through a little bit later on, there's a Master Strategy Day. If you use the code STRATEGISTS, so that's capital STRATEGISTS, strategists, then you get a $50 discount. So instead of the $195, which is fantastic value for 7 CPD and 7 CPE points, but more importantly, some of the strategies that you'll be seeing on the day, including SMSF testamentary trusts. I'm going to be rolling out the new Protector 2, which is, it puts the existing Protector virtually in the shade. So it's a much better, more glamorous, more elegant system. And you're going to be wanting to do that, roll that out for basically every client. We're going to be looking at shareholders agreements, unit holders agreements. We're going to be looking at some recent changes to our leading member discretionary trust and SMSFs to tighten up that bloodline side. So there's a lot for myself. Tim's going to be coming along and looking at a lot of tax strategies. We're going to be looking at a lot of asset protection, value plan pricing, and Michael Jeffries is going to be looking at some issues in relation to liquidation, businesses, post JobKeeper, and also more importantly, employee share plans. So you can come along for the day, $145, what a bonus. And look, I can guarantee you're going to make a lot of money out of that. So these are all high revenue paying strategies. And I've got some absolutely amazing ones that you'll really need to put in place before 30 June. And I'm going to show you a couple of good strategies just recently did, how to wipe out Division 7A using a property and also a self-managed super fund. That in itself is worth the weight in gold. And I mean, really, $145, most of the strategies we're talking about are going to be worth at least $4,000 to $5,000 for your clients. And of course, the family allowance agreement, which will get rid of that death duty, that death or the 17% on taxable contributions going to your adult children and grandchildren. So that's worthwhile. Make sure you book that in. Even if you register, can't make it for the full day, obviously the whole thing is videotaped. The whole show, notes, everything will be there for you. Anyway, so let's go along and have a look at our agenda for today. Some of the problems with old discretionary trustees, some of the issues we'll look at. Obviously not covering the streaming of income. You might not have an appointor in there, or the appointer's dead or passed away. No succession of appointors to carry on control, which is absolutely crucial. If we want these trusts to last forever and a day, well, at least up to 80 years, which is still against perpetuities, unless you're in South Australia, we need to have a chain of appointors, because effectively appointors are really the kings and the queens of the trust. Old, dead or redundant beneficiaries, if they're sitting on the actual trust deed, you just need to get rid of them. So we want to cover those sort of issues, some of the old ones. I want to spend a bit of time going through line by line TD 2012/21, which was the Commissioner's response in relation to resettlement post-Bamford. And he did an absolute excellent job around that resettlement. So we're going to spend the bulk of our time on that. I'm going to show you 2 trust deeds. In fact, I'm going to show you 3 trust deeds. 2 that are quite easy to vary, 1 that would be very, very difficult. In fact, it's not even a discretionary trust deed. So I'll talk about that. We'll talk about how you can get assistance from Abbott-Family if you really need to. I'm going to be looking at I'll show you some material on the difference between a discretionary trust and a leading member discretionary trust, which you can show your clients, and these will be available when this video comes out this afternoon. I'll put these, the slides and also a lot of this material in the show notes. So I'll be putting TD 2012/21 in the show notes. I'll be putting in a 3-page flyer on the difference between a discretionary trust and leading member discretionary trust. Obviously, this video, plus I'll put in Bamford just to give you something else to read, and also obviously the video as well. I also want to, at the end, just show you through how to change the name of a discretionary trust, changing beneficiaries, appointors, principals or trustee. So we've got a very unique LightYear doc solution on that. It took me 6 months to develop, and essentially for that is you can do it all in one, particularly if you've had clients had one relationship who's been tied up in a trust and now they're in a new relationship, or things come and go. So I'm going to take you through that. It's a very simple solution, but you know, it's very effective. Generally, if we're at Abbott-Family, we charge $750 for that if it went to a retail client. Okay, as I said before, if it's too hard, then essentially feel free to use Abbott-Family. Essentially, in some instances, the deeds can be very old. If there've been a number of changes in the rules, trusteeship, etc., to go way back, you'll need to really maybe utilise our particular expertise in that. There is a pretty famous case with a fairly famous law firm who did 2 discretionary trust variations. It's a very, very nasty family affair, criminals, the whole works. They got one right and they got one wrong. So, do you know what I mean? It's notwithstanding the skills of lawyers, and these guys are really top flight, they made a mistake and they got one right, one wrong. So again, we don't make those sort of mistakes at Abbott-Family. Depends on how complex it is, but generally it's $595 for a discretionary trust deed upgrade. And remember, you just give us the nasty ones, and it's only $495 if you're a strategist member. Obviously, if you're a strategist member, the bulk of the discretionary trust upgrades you'll be able to do, and effectively you'll go on the system. But you will come across one or two that are pretty diabolical. So let's just bounce out of here. And then what I want to do is go to the tax office resettlement. What I'll do is, hopefully you can all see that. I'm going to mark it up as we go through so that when you go through, you're going to have a look at the highlighted areas. So this came out post Bamford. So the question is income tax. Does CGT event E1 or E2 in sections 104-55 or 104-60 of the Income Tax Assessment Act happen if the terms of a trust are changed pursuant to, and this is important, a valid exercise of power contained within the trust constituent document or varied with the approval of a relevant court? So first off is if we just put a minute, and I have seen this, a minute that the trustee is going to vary the trustee, generally that's not going to be good enough. You need to actually do a deed of variation. The problem is if that is then struck down, then effectively you're caught all stretch of the imagination. So what we're going to do is go through and have a look at what the Commissioner says. So we've got that question again, is it 1 or 2? We go there and the Commissioner says no. That's a good one, isn't it? It sounds like a little Britain. The Commissioner says no. So that's a good one for us. We've been told for 20 or 30 years that it's a potential yes because you change anything, and effectively it is going to be a brand new trust, which would be a CGT event. Now there is one instance, and I want to carry that a bit later on, when we look at sub-trusts, and I'll talk about that. In fact, I won't talk about it, I'll let the Commissioner do it, whereby there is a resettlement. But where we change beneficiaries, appointors, so on and so forth, there is no resettlement. Anyway, so let's let's not look at what I say. Let's have a look at what the Commissioner says. So in these circumstances, neither CGT event E1 or E2 in 104-55, 104-60 happens unless the change causes the existing trust to terminate and a new trust to arise for trust law purposes. Hence, that's, remember we talked about that, closing one down and starting a brand new one, a resettlement, or the effect of the change of court-approved variation is such as to lead to a particular asset being subject, and this is where it starts, an asset of the trust being subject to a separate charter of rights and obligations, such as to give rise to the conclusion that that asset has been settled on terms of a different trust. Does that make sense? So let's go through and see what the Commissioner has to say. Example, and fantastic, getting straight into it, the examples. The Acorn Trust is a family discretionary trust that was settled to benefit the members of the Squirrel family. Under the terms of the trustee, a private company in which Mr. and Mrs. Squirrel are directors, you want to make sure you've got a successor director solution for that one, absolutely, has the power at its absolute discretion to appoint income to any one or more of the general beneficiaries, which is fairly typical. The general beneficiaries are defined under the terms of the trustee to be Mr. Squirrel, his wife, their children, their grandchildren, Oak Proprietary Limited, which is a private company through which the family runs a business of growing flowers to supply local forests. So that's probably their de facto bucket company. Probably doesn't make sense really from an asset protection point of view to actually distribute down to a business, a risky business. So it doesn't make sense. You're better off having a private company, but obviously the Commissioner is looking at it from a tax perspective and not looking for an asset protection. Having decided to get out of the flowering industry, the Squirrel family disposed of their interest in Oak Proprietary Limited to an unrelated party. The trustee for the Acorn Trust, and this is important, provides for a procedure for the trust to be amended, namely by trustee resolution recorded in writing. So if we have a look at that, again, my preference is to actually do it by way of a deed, but certainly you can do it by way of a resolution in writing. Pursuant to this procedure, the trustee resolves in writing to amend the deed to specifically remove Oak Proprietary Limited by name from the class of general beneficiaries. The trustee further resolves to add to the class of general beneficiaries the respective spouses of the children. So we're now starting to open it up. Trust and companies in which the family has a majority controlling interest, and a philanthropic charity unrelated to the Squirrel family. Now, normally, the first thing, if you went to probably 10 lawyers around your area and said, this is what you want to do, first thing they'd come back to you and say, well, there's a resettlement there. 5, the making of these resolutions being, and this is again, being a valid appointment, a power of amendment contained within the deed, does not give rise to the happening of a CGT event. Expansion of a power to invest. The hedgehog, and look, this is usually most discretionary trustees have wide powers to invest, but the Hedgehog Investment Trust is a unit trust. And this is why, as I said, this talks about SMSFs, testamentary trusts, child maintenance trusts, etc. So the Hedgehog Investment Trust is a unit trust. The unit holders, which are a group of 5 persons who have pooled monies in order to invest in the stock market. Under the trustee of the trust has the power to invest in listed securities. Included in the deed is a provision which permits amendment of the deed with the consent of all the unit holders. Again, it's not a bad idea. Following a meeting, the unit holders, of which they unanimously agree the range of assets with the trust invest should be expanded to include real property. The trustee resolves to amend the deed to correspondingly explain the class of assets in which the trustee is empowered to invest. The making of the resolution, again, being a valid exercise of a power of amendment contained within the deed, does not give rise to the happening of a CGT event. So we're doing quite well. Okay, now here we go. This is why this definition or determination was made, is addition of income, power to stream and extension of vesting date. The Lime Trust is a discretionary trust settled in 1980. So that's a long time. I'm going to show you one a bit later, which is 1970, to benefit the members of the Linden family. The trustee contains no definition of income, nor does the deed contain provision of the trustee of the trust to stream income. Now, the reason that was the case is because up until 2010, the High Court case, none of us thought there was the ability to stream. It was considered, but if you went and had a chat with lawyers, 50% would say yes, 50% would say no. It's very tortured, but out of obviously Bamford came a whole new set of rules, much the same as this resettlement we're looking at. And you get to see why the Commissioner had to be so practical, because to amend and upgrade all of those trustees to enable Bamford, as in this example 3, if he wasn't flexible, hadn't gone to deep dive into all the legislative occurrences and case law, then there would obviously be a resettlement and no one would be there with Bamford. So anyway, and believe it or not, there's, I think at the moment, 870,000 family trusts or discretionary trusts in Australia, which are all primed for upgrading. In fact, when was the last time you upgraded your clients' discretionary trustees? Anyway, let's go down. The trustee contains no definition of income, nor does the deed contain a provision permitting the trustee of the fund to stream income. The deed contains a clause specifying the date at which the trust is to vest as at 30 September 2020. Pursuant to an unfair power of amendment in the deed, the trustee resolves in writing to amend the deed, and again, my preference is to use an actual deed, unless it's just like a resolution for beneficiaries, to amend the deed to insert 2 clauses. One, the first defining the income of the trust to equal the net income of the trust as calculated under Section 95(1) of the Income Tax Assessment Act, excluding franking credits unless the trustee otherwise determines. The second, authorising the trustee to separately identify and label various sources of income or receipts that form part of the income of the trust estate to deal with those amounts by reference to their labelling. That is to stream particular source of income to particular beneficiaries. So that's Bamford versus FCT. The trustee further resolves to amend the deed by changing the vesting date to 30 September 2050 or such earlier date as the trustee may determine. Now, obviously, with that extension, it has to be within the 80 years of the original one. But the fact of changing the vesting date is fundamentally such a big thing. I can show you articles where people have said in the past that it's a resettlement. Clearly, the Commissioner has said it's not the case. The making of the resolutions being a valid exercise power of amendment contained within the deed does not give rise to a happening of a CGT event. Extension of the vesting date. The Wombat-Family Trust, a discretionary trust, settled on 31st of March 1981 to benefit the members of the Wombat family. So 80 years from that would make it 2061. I don't think we'll be around at that. Well, I won't anyway. The eligible beneficiaries of the trust are defined as Mr. William Wombat, his spouse Wanda, any of his children or grandchildren born before the trust vesting date, and any spouse of his or his children or grandchildren born before the vesting date. The deed contains a clause specify the vesting date as 31st of March 2021, so it was only a 40-year trust, which is crazy. The trustee also contains a clause granting the trustee a power of variation. See all of this, where the Commissioner always, the first thing is, what's the process, what's the power of variation? So that's where you need to look at to find how to do it, and I'll take you through an exercise on that. So the trustee also contains a clause granting the trustee a power of variation that can be exercised prior to the vesting date, and which includes enlarging any category of eligible beneficiaries so far as the power shall not infringe the rule against perpetuities. The trustee wishes to extend the vesting date of the trust so as to enlarge the class of eligible beneficiaries that may benefit under the trust, include children, grandchildren, obviously 40 years, and great-grandchildren may not be able to do that, or grandchildren born after the vesting date. The trustee resolves to extend the vesting date to 31st of March 2051. Extending the vesting date will not infringe the rule against perpetuities, which is 80 years, so we're only taking to 70 years. And of course, we can go down the track when they get to 2040, they might take it out for another 20 years. The clause governing the trustee's power to vary the trustee contemplates that enlarging the category of eligible beneficiaries may involve extending the vesting date of the trust, given the specific limitation of the trustee's powers for not infringing the rule against perpetuities. The trustee's resolution is a valid exercise of the amendment power. The making the resolution being a valid exercise of a power of variation contained with the trustee does not give the rise to the happening of a CGT event. The result would be the same if the vesting date was extended with the approval of a relevant court rather than under the trustee. So that's fairly important. Now, this is absolutely crucial to understand where we do fit in there. So stamp duty, you'll see when we get in, Brad, really good question. When we get into the law, the Commissioner obviously just doesn't fly off the hat. He's got a whole body of law that we're going to look at very shortly, but good question. But I want you to focus in on this one because this is where resettlement arises. The hedgerow trust is a discretionary trust, the class of objects of which consists of a large number of entities associated with the Buttercup family. Under its terms, the trustee has a wide range of powers, including the power to declare the particular assets of the trust are to be held exclusively for one or more trust objects to the exclusion of other objects of the trust. In exercise of this power, the trustee declares that one of the several assets forming part of the corpus of the trust, asset one, we'll just call property, was henceforth held exclusively in trust for one of the objects, Badger, subject to the trustee's other powers, such as powers sale. 1 month later, the trustee makes a second declaration of similar effect in favour of Mr. Badger in respect of one of the remaining assets of the hedgerow trust, asset number 2. While the respective declarations do not terminate the hedgerow trust, absolutely, the effect of the declarations that assets 1 and 2 are no longer held on that trust. Rather, the trust obligations attaching those assets have changed in a manner consistent with the conclusion the assets commence to be held on the terms of a separate trust for the benefit of Mr. Badger as sole beneficiary. As a result, CGT event E1 happens when the separate trust for the benefit Ms. Badger is created over asset 1. CGT event E2 happens with asset 2 is also transferred to that separate trust. So that's the original hedgerow trust doesn't change, but what we're doing is we're pulling an asset out and setting up a separate trust for one of our individuals. And this is one of the things you're going to see that we're building for those of you, and I'll be talking about this on the master strategy is crucial, is that we're now moving in Australia, we're moving to more what we call living trusts or family protection trusts. So these are trusts that are settled prior to death, and it can be done by a protector or protector two, so that essentially on death, the assets, not the assets of the fund, but the value of the assets of the fund are tied up in this trust. Now, what will happen on death, there's an amount that's being owed to the trustee of the Family Protection Trust, who obviously go to the executor of the estate and then seek recompense or payout of that loan. That loan amount will come into our Family Protection Trust, and that'll be okay. So then we can get our monies in there, and then we can set up a separate subtrust. So it could go from John Smith to Sally Smith, his spouse originally, and then effectively what we can do is then we can put cash into separate subtrusts for children. So what it is, it's a testamentary trust, well, like a set of rules and regulations built within each of these trusts, but we're using cash. It'll be different, of course, if there is then a property sitting in there. We pull that property out and say, well, this is for young Max Smith, this farming property. That is when we're going to create a brand new trust. The original trust won't change. There's no resettlement there, but pulling that asset out and setting it into a new trust effectively is a new trust, if that makes sense. So that's, Debbie, well done. In fact, I was going to cover that, Debbie, but you're well and truly in touch with me. So snaps for Debbie Potts. Where we create separate subtrusts for Division 7A, they will effectively be brand new trusts, obviously, as well. So I'm working on that. I'm working on this philosophy as well, how we can ensure that when we start to provide advice around these living trusts, which is quite apart from our will and our estate as accountants and financial planners and also lawyers, how it all fits in there. So hopefully getting an understanding of where the commissioner sits, and we're going to go in and have a look at that, and then we'll come back from that a little bit later on. Just on one thing, there's a really good question there again. So when we have a look at that from Chris Becks, it's a fantastic one. The rule against perpetuities doesn't apply in South Australia. So when you set up a discretionary trust, effectively in, for example, I'll go through it. If you set up a discretionary trust in New South Wales, Victoria, West Australia, everywhere, the ATO rule applies. The Trust Act in South Australia provides that rule against perpetuities, the ATO rule, doesn't apply. So if you choose, when you go through our system and you're establishing a trust, effectively that the jurisdiction is to be South Australia, the original jurisdiction, then the rule against perpetuities doesn't apply. Notwithstanding, the trustee may be outside of South Australia, as is the property, but you can choose the jurisdiction as being South Australia. The question that I'm looking at, and we'll look at it in the context of this determination, is it possible to change the jurisdiction of the, is it possible to change the jurisdiction so that there is no resettlement? And I've just got to have a look at that one. Anyway, date of effect, subject to exception mentioned in paragraph 13, this determination applies both before and after its date of issue. Now, how fantastic is that? It's virtually saying all those times you've been told it's a resettlement, even before 2012, it's all irrelevant. So it now means we've got open slather for everything. It also means that if you have gone through an upgrade previously, provided it is consistent with the processes and procedures of the existing trust and the variation amendment clauses in there, then you're okay. 13, in any case where the views expressed in this determination are less favourable to the taxpayer than the Commissioner's previous practice, creation of a new trust, it does not apply. So we won't worry about that one. Okay, so now this is where we get into the guts of it around resettlement. So Brad, I want you to get those ears up so we can have a look. So CGT event 1 happens if a trust is created over CGT asset by declaration or settlement. One question that has, so for example, if I've got an existing house and I put a trust over the top of it, a declaration of trust, then obviously there has been a disposal under E1. One question that has arisen concerning the scope of this event is whether an existing trust can change in such a fundamental way. Remember, this is what we've been told for a long time, and I love that myth busting. And you want the best person to bust all our myths is the Commissioner, because it's very hard for the legal fraternity to argue. So concerning the scope of this event is whether existing trust can change in such a fundamental way that although the trust is not terminated for trust law purposes, because it doesn't, nonetheless for tax purposes a new trust has come into being. Okay, so here we go. In June 1999, in response to the full federal court's decision in Federal Commission of Taxation versus Commercial Nominees, which is a great case to read, probably a bit boring for you guys, but I love it. The Commissioner published a statement of principles to guide taxpayers, advisors and ATO decision makers when the Commissioner would treat changes to a trust as giving rise to a new trust estate for income tax purposes. The basic proposition underlying the statement was that a new trust arises for these purposes where there is a fundamental change to the trust relationship and that a change in the essential nature and character of the trust relationship can result in the creation of a new trust. Okay, so on the 21st of January 2011, the full federal court, Dick Edmonds, know him well, handed down in its judgment the Commission of Taxation versus Clark, or Clark's case. That case raised separately for consideration the circumstances in which the nature of a trust is so changed it might be concluded that the trust that originally incurred capital losses, and this is pretty important, guys, is not the same trust for income tax purposes as that which derived gains against which the losses are sought to be recouped. You can see why the Commission was having a ping at it, because if you could say it was a brand new trust, then those losses are evaporated. Clark was decided adversely to the Commissioner. Special leave sought by the Commissioner of Appeal decision of the High Court was rejected on 2nd of September 2011. So you can see here there's been paragraphs that originally were in there, but it's been updated since then. It is clear, following Clark, that at least in the context of recoupment of losses, continuity of a trust estate will be maintained so long as the trust is not terminated for trust law purposes. As such, in the absence of termination, tax losses being carried forward by a trustee, as a general rule, remain available to recoup against relevant trust income derived in future years, which is good. Furthermore, as a general proposition, it would seem that the approach adopted by the full federal court in commercial nominees, as explained by Dick Edmonds and Gordon J.J. and Clark, is authority for a proposition that, assuming there is some continuity of property and membership of the trust, an amendment to the trust that is made in proper exercise, again, of the power of amendment contained under the deed, will not have the result of terminating the trust, irrespective of the extent of the amendments so made, so long as the amendments are properly supported by that power of variation. Relevantly, in commercial nominees, the full federal court had stated that in order to determine whether losses of particular trust property are allowable as a deduction from income accruing to the trust property in subsequent income year, it will be necessary to establish some degree of continuity of the trust property or corpus that earns the income from the income year of the loss of the year of income. Also be necessary to establish continuity of the regime of trust obligations affecting the property in the sense that while amendment of those obligations might occur, any amendment must be in accordance with the terms of the original trust. So that variation clause is absolutely crucial. So long as any amendment of the trust obligations relating to such trust property is made in accordance with any power conferred by the instrument creating the obligations and continuity of property as subject to the trust obligation is established, there will be identity of the taxpayer. So there is not a new taxpayer. Because obviously if you had a new trust, it's a new taxpayer. The Commissioner formerly, and this is not me, this is the Commissioner talking, had been of the view that the High Court and Federal Commissioner versus commercial nominees had advanced what on its face appeared to be a different test. That is, the Commissioner's view at the time, the High Court had seemed to not only focus on where the trust had come to an end, but had also envisaged that changes to one or more of the property membership and operation of trust might be sufficient to result in a loss of continuity, even if trust had not terminated. However, this is our big one. This is the Commissioner saying that, and again, look, anyway, but just this is the paragraph for all of us. However, in light of the Federal Court's decision in Clark and the High Court's disposal of the Commissioner's special leave application, it is apparent that continuity of trust is a function of whether the trust continues in existence under trust law in contradistinction to having been terminated, which is a vesting. Obviously, when you vest, so if it continues to make the changes, then under trust law, it does so continue. As so understood, the comments made by the Federal Court and commercial nominees relating amendments to trust obligations is good law. Okay, so effective the change of terms of the trust. I'm running out a bit of time, but look, I'll put this in the show notes, which will be sitting up there. Look, have a look at all of this stuff. I couldn't even write a better brief than this. Obviously, they've got a barrister or two to go into it. So again, if we have a look at that, Lamb and Kim's a good one. If we go through there, and essentially we've got all the case references. If you want to have a look through there, you can't really beat that. So that for me is the key there. As long as we've got the original trust, and of course, what's the big thing? We vary it in accordance with that particular deed. So what I want to do now is just have a look at a couple of deeds that we've got here, and I'll just show you how to do it. Now, where have I got that? Okay, so this is from a site, what's it called? Legal E-Docs. Thank you very much for that. Legal E-Docs, Blackrock, Victoria, lovely spot. So what we're doing here is we're going through the consent to act document. Generally, you won't find that in our deeds to establish a fund because it's actually embedded into the deed itself that the trustees give their consent. The problem about it is if you have separate documents and they get lost, then how can you prove that it's actually a consent to act? So it's better to have it in that original deed. As an aside, if you can't find a deed, then if you want at Abbott-Family, we can do a deed of loss deed and upgrade the deed itself if you want. So let's go through. So I've got here, again, that's a very dangerous document there, the consent to act. Let's go through and have a look. Okay, so here I've got the power to amend the trustee. So that is the key for us. Remember, we're having a look at it. So the power to amend the trustee. So I'm going to go through that. So it's on page 11, I think. So the retirement trustee. Oh no, it's 11, sorry. Clause 11, silly me. Resettlement, 8, 9, 10. Okay, power to amend the trustee. This clause explains how the deed may be amended and the restrictions on the ability to amend the deed. Subject to clause, subclause 13F. And when you get something like that, if you're not really comfortable with it, again, this would be something where Abbott-Family can come in and amend the deed for $5.95 or $4.95 if you're a strategist. But you've got here, I'll show you how I read it. So subject to subclause 13F and the remaining subclause of clause 11, which we'll look at, the trustee may at any time before the vesting date and with the prior written consent of the appointor, if there is one, amend, add to or delete all or any of the trust created by the deed or all any of the provisions of the deed, including the schedule, the annexure. So eventually you can throw out all the things and then bring it in there. Then we go down, C, so amendment or addition or deletion of this deed under the above subclause may extend the vesting date beyond the date stated or described in the schedule. Now, I'm not really a big fan of that because what it is, if you put that in, remember those two clauses the Commissioner had in there effectively would create a problem there because, again, you can't amend that. So this is, again, not a very good deed because you can't change the vesting date from what you put in there. D, no amendment or addition or deletion of this deed will be effective if it purports to reduce the present entitlement of a beneficiary to income or capital of the trust. So the only problem about that, again, it's not a very good clause there because if you delete a beneficiary, then obviously that's going to it's not going to reduce their present entitlement. It would only be if there's also a declaration of it. So that's not going to be an issue. The exercise of power to amend, add or delete from this will not be effective unless it is writing is properly signed or recorded by the trustee. Again, you can do a resolution, but my preference is by a deed. Without limiting the generality of subclauses F and subject clause C, D and E, the trustee may at any time amend the deed to expand the powers vested in the trustee. So now I've got to do, remember this says subject to subclause 13F. So that means that's our exception. So virtually we can do anything. The only problem here is I've got a vesting date. And if you have clauses like this, just send them through to me on support. I'll have a look at them and I'll say, okay, well, this is what I would do. You can do it through your LightYear docs, which I'll show you in a sec. Alternatively, we may need to do it through Abbott-Family. So 13, so it's 13F. So we go down. 13F, this just shows you how stupid it's being drafted. The preceding subclause may not be amended, deleted or variated in any way, and any clause in this deed is inconsistent. And essentially, this is notwithstanding above, the settlor may not be a beneficiary and may not benefit in any way under the deed, which generally is the case. So it's a roundabout way that apart from vesting date, we can amend this deed quite easily. Now, I've got another one here. This is a ClearDocs deed. And I've just got here, this is pretty simple. So the trustee may vary the deed at any time before the vesting day, even to the extent of revoking all the trust established, but only with the consent of the appointor. And I would always put appointor consent anyway. It's far better to add it rather than not have it. The trustee must do so by executing another deed. Again, always get the appointor to sign off, always get the trustee, and then obviously always do it by deed. It seems to be the best. Variation not to cause vesting after the vesting day. So again, we've got some pretty weird ones there. Let me just have a look while I'm here as to whether they've got a definition of a vesting day. So it's not there. So it might be right at the back end. Here, vesting days means the first to occur of the expiration of the perpetuity period. So again, that's the ATO rule or such earlier date if there's in writing. The only problem about that one is it's not very well written because if there is no perpetuity period, then that doesn't make sense. But anyway, that's their constructs. That's Maddox. It's not my issue. So we've got a couple there. We're going to do a deed variation. So What we do is we just bounce into our LightYear docs, and what we'll do there is you've got your master strategy day. Remember, guys, make sure you sign up for that. Put in place the code strategist. You'll see here in the tickets, hopefully there. Just get the code. Make sure that you get that from our guys. I'll just put the code here in the chat. So the code is strategist. So if you do that, that'll give you $50 off. And what a huge bonus that is anyway. So anyway, we're going to go to our documents. I'm obviously going to go down to the trust section. I will look here. I'm just going to look at a strategic trust. I'm not going to have a look at leading member. We'll look at that on the master strategy day, but I'm just going to look at the simple but strategic discretionary trust. So upgraded discretionary trust to a LightYear Docs strategic discretionary trust. So I'm going to start the document. Obviously, I'm going to need, and I'll just put this in Abbott test, and I'm just going to put the Smith DT upgrade. Now, I'm going to need, alongside me when I do this, the existing deed. So as you can see, it's the whole guts of what we need. As I said, if you're a little bit concerned, then come back to me. I'll show you just while we're here. Okay. So, well, okay. 1962 Memo and Articles of Association. You've got to get rid of that. That's the first thing. You can do that under the Corps Act. So if you've got anything smelly and old like that, just get rid of it. I've got here, where did I do it? Where did I do it? Sorry. Yeah, I don't think I've got it there. So, oh, here we go. Okay, so when you see something like this, 17th April 1970, deed of settlement, don't try and do it yourself. Make sure that comes through to Abbott-Family, because there's just too many, weird and wacky things. In fact, when I went through this trust deed, it wasn't even a discretionary trust deed. It was a trust that was built for death duties in the day. So it's actually an estate planning deed. So you want to make sure that you don't get involved in that sort of process. If it's old, you can do it through Abbott-Family. As I said, it's not an expensive process. But for you, let's go back and have a look at what we do. So we've got the Smith DT upgrade. Use your Abbott-Family code, AM001. So the general, what's the existing name of the trust? And I'll show you how to change that a little bit later. Smith Family Trust. When was the original discretionary trust started? So we go into the deed, and it should have the original startup date, so 2001. Date of the deed of variation. Now, you might not know, it's going to be the date when you generally execute this deed. And again, you can see this is a deed of upgrade or variation. Please select the state in which the legislation applies this agreement. I'm going to choose New South Wales, but again, what we would do for that one is potentially I have to look at whether we could do South Australia, which is important. Now, vesting is important, so we can either, at the end of the day, all prior beneficiaries, spouses, companies and all that can be the last ones, because on vesting, you have to get the capital and obviously transfer it out. So that's one of the dangers about going outside South Australia. Now, that means it's when it comes out, it's obviously CGT stamp duty. But if there are no beneficiaries, then you can have a default beneficiary being a charity. And obviously, if it's a charity, then obviously they won't be taxed on any of those bequests. So enter the rule number below clause 2.1. So what I'm doing there is looking at the deed. So we're looking at clear docs, and I think I don't know, did you guys help me? Power to, I go variation. Okay, so trustee may vary the deed under 57. So trustee may not vary clauses 34 or 38. Why do they do that? They're just so frustrating. 34 and 38. So 34, okay, again, the set law. So that's okay. And okay, a beneficiary is under no obligation, whatever, to personally indemnify the trustee. So that both of those are carried through to our existing deeds anyway, so it's not a big issue. So the clause that we're looking for there is going to be 51. So we just poke that in, 51. So select the parties involved. What I'm going to do there is the appointor. Oh, sorry, go back. I forgot to see that little button. Has it been varied in the past? If it has, then you've got to put in the dates of variation. I'll assume this is the only case. Now, we insert the trustee's details, and we've got Smith nominees, Pty Limited. We put in the ACN. So there's no difference if you've ever upgraded a SMSF, it's exactly the same process because, again, a self-managed super fund is a trust. So how many directors? I'm just going to have one here just to save ourselves a bit of time because I've got a couple of things to show you. Next, please enter the appointer's details. So the first name is John Smith, 100 Smith Street, Sydney, New South Wales, 2000. Now, what I am doing is part of this process, because a lot of trusts I see don't have successor appointors. When you get to this page, you'll actually be given the option of adding successive appointors if you want. So building a chain of appointors, which is useful. So the beneficiary, any beneficiaries are individual, yes. So you can go back to your original deed, but you can change them all if you want. Is there a company? Yes. An incorporated association, which is a charity, will go no. So individual beneficiary, I'm just going to select because I should have John up there, I think. In fact, I think it's going to be 100 Smith Street. And that's John Smith. Now, again, I can make changes. I'm going to bring in add another beneficiary. I'm going to bring in his girlfriend, Jane Brown, who lives at 100 Brown Street, Sydney, New South Wales, 2000. So again, adding that, she wasn't even in it to start off with. That is not a resettlement because we're able to do it under the power of the deed. Corporate beneficiary, we've just got there Smith, a bouquet. Wait until you see some of the strategies I've got for Div 7A. It's going to blow your mind. So make sure you come along to that strategy day. If you haven't got the time or you're busy on that day, just book it in so that you can get all the juicy stuff. Okay, so that's it. Finish. I'm just going through the process and that will come up as a PDF. Again, you can't change the actual underlying laws or the deed of variation. You're just simply putting in the data. Abbott-Family have signed off on the actual process to do that. As long as it's done in accordance with, again, it's done in accordance with the deed of the variation clauses. So discretionary trust deed, variation of the Smith Family Trust, the strategic discretionary trust. Now, as part of our licensing with Abbott-Family, I'm on both sides, we need to put this disclaimer in. But if you don't want it in for your clients, it's a PDF, please feel free to take that out. You can easily go to, like I've got Nitro or Adobe, just extract or delete that page if you want. So that's not going to impact the legal side of things. So deed of variation for the Smith family, we've got the trustee, the appointor. The trustee established a trust on the 1st December. The appointed and the trustee, again, have agreed to vary. Remember I said trustee and appointor. Variation of the trust rules meet 2012/21. It's got the same vesting date. And then we just go into the, as I said, we've got the primary beneficiary. We've made changes there. As I said, we will be adding tomorrow, if you go and pull this up, there'll be a chain and succession of appointors. So that essentially is how easy it is to upgrade a discretionary trust without a resettlement. Bradley Smith, if there are two appointers, you'll need to have both appointers sign the variation. No, you want to get both ones to sign if there's two appointors. But remember, if there's a succession, so it's John Smith, then Max Smith is the next one in line, then Max doesn't have to sign. It's only the appointer at the time. Debbie, what year would the rule of thumb for deeds that we shouldn't touch? I think honestly, Debbie, the one I saw it's a pretty famous Western Australian case. In fact, I think I've just got it here, so you can have a look. I'll put this case up there for us. This was one that was done by, look, it's just a super nasty case. And funny, as I said before, McCanty and McCanty, look, it's a really long case, involves criminals, involves everyone. But in that case, a fairly big legal firm over in West Australia did two variations. One was effective, one was not effective. So what date should you go back? You know, I think most of the times you'll find probably from 1990 you're going to be okay. But remember, the key for us is going to be that variation and that amendment clause. If you are concerned about it or you don't understand it, we saw a couple of simple ones there, then send it to us on support. I'll have a look at it. And if it looks as though it's going to be a nasty one, then we can do it through Abbott-Family. Otherwise, you can do it yourself if that makes sense. If you're going to look at, so how do you find out if the deed has been varied before? If you don't have any documents, Brad, then you're in problems. Generally, it's the same as an SMSF deed or a discretionary trust. If you've done a variation, so you'll actually see in this variation, what will happen is it talks about the original deed and then it'll have the date of execution. And you notice in the interview, it says, has it been varied before? And you'll generally pick that up from the last variation that you've done. If you can't find it, then just let us know, and it's generally going to be the date. If there has been no variation or no one can find it, then effectively, if there's an issue, which has happened in this McCanty case, you're actually going to have to find out what that particular clauses are. But again, deed of lost deed, feel free and we can help you there. A couple of the little ones that I want to show you up on our support centre. So that's, if you look at our support centre, and I'll put this in the show notes as well, the difference between a discretionary trust and a leading member trust. Importantly from that one, it really, as you can see, you can just download it, send it to a client. If you're looking at deed upgrades, I would say that the pricing of a deed upgrade is between $350 to $500 you should be charging for it. And I'd actually go through a whole process and get rid of all your clients' old deeds, or at least spend some time if you've got it. Again, it's not a bad, if you've got 100, if you've got like 200 client discretionary trust deeds, I'll be drafting up a letter, and hopefully Tim Munro will be drafting up a letter going out and talking about the importance. But again, if they want, you can say, well, what we've got there is an opportunity to make it a bloodline deed. And then that's the leading member one, which I'll cover more on our Master Strategy Day. But we've got that. All of you can access that straight. You saw I just went to the Strategy Centre, went into client emails, went to leading member, and then we've got this as well. So it goes through the process of leading member succession, how to do it, what we need to do, and then off running, and even talks about leading member SMSF. So if we have a look at that, we looked at SMSFs, which can be upgraded. We've looked at that. I think I've got one more thing just to have a look at from our perspective. So we looked at the deeds, really old deed. Debbie, please make sure you come to us. What else did I have a look at? Sorry. Okay, yeah. So the last one, I knew there was something. So you'll find here up on the site that in our documents, I won't go through it, I'll just show you what it looks like. So we go down to trusts, we go down to standard trust, other trust documents and minutes. Remember, guys, you're going to have to do your trust distributions very shortly. So Michael will be out dealing with that, but it's a good idea to get those up and running because once it's in the system, you can't lose it. So you want to do change of discretionary trusts, positions and names. So I'm just going to go Abbott test. We're going to go to Smith Family Trust, and I'll just show you what to do just quickly. Just give me 2 minutes before we finish up. And then I'll just show you what we've got here. AM001. AM001. So if we go there, general, so what's the name of the trust? That's okay, I'm not going to do it in for you. Has the trust been varied in the past, post the date of the establishment? Then you put that in the case. So this is the original execution. When was the original deed established? Are there any changes to the position in the trusts? And position means beneficiaries, appointors, etc. Does the trustee want to change the name of the trust? Well, we can go yes, and then we can change the name. So we can call it the, remember, because we've now got Brown in it. So is there a appointor? Yes. And so when we come down, we've got the trustee. I'll jump through that one. The current appointor we put in, and then we have the changing party. So what we can do here is we're going to change the position of beneficiary. So we're going to replace or retire that beneficiary, and then it's going to be the individual. We can put the name in there and so on and so forth. So then if we wanted to add a new beneficiary, then we just go add another, and then we could put beneficiary, new, and put their details in there as well. Then we can go and add another one. We could put in there, we're getting rid of the principal, so they're retiring, so on and so forth, and appointors. So you can do a whole swathe of things. And what will happen is then, each time you've clicked on for a beneficiary, the principal or the change in trust name, you need to go into the deed to see what is enabled to do that. So it's not much different than what you generally do with your trust distribution minutes. So that's if you want to do any change whatsoever to the beneficiaries, so on and so forth. But if you're just looking at throwing out the old rules and putting in the new rules without a resettlement, then you're going to go down and do that variation, which is pretty crucial. Brian says, grant of client that needs advice on asset protection in light of divorce and ex-partner legal actions, sole trader, trading company. Okay, so Brian, you can either send that to me or give me a call. In fact, probably best is for something like that to put it on the support ticket with all the details. That way I can get around to it and I don't lose it rather than email. And then what we can do is we can work out a time to have a chat. How do we do with the death of the beneficiary when updating deeds? Well, if they've already died, when you go through that updating, that's why you'll see you won't include them as the beneficiary. So when we go through that updating process, remember said, is there an individual as a beneficiary? We go yes. Then effectively what will happen is we put in our new range of beneficiaries. So that's the easiest way of doing that. Because once you're dead, obviously you're not a beneficiary anymore anyway, because you're not alive. Okay, so yeah, so this is is a great form to this for where there has been marital changes. Now, I can tell you if you went through, this would cost you easily $1,100 if you went to a legal firm. It took me 6 months to build this. Anyway, look, we're getting to our stuff. Rajiv, the master strategy day, the promo code. In fact, what I'm going to do, I'm going to show you where it is. So this is the Eventbrite that I've got here. Let me just go in to here. Oh, so that's the wrong one. Just want to make sure I give you the right one, Rajiv. And look, honestly, you all must attend because it's going to be a crackerjack of a session. You should see some of the strategies I've got. I know Tim always has a huge ones. So we've got the Master Strategy Day. We're looking to get up to a couple of hundred on that one, which I think will is to be done. If you're not there, you're going to miss out on a lot of stuff. So come on. I don't know why it's not doing that. Oh, sorry. Here we go. Something's working. Oh, here we go. So tickets. So I want to make sure I give you guys the proper promo code. So there you go. The promo code is strategists. So as I said, strategist gives you a $50 discount. So have a look at strategist there. So I'll just put that up here in the chat again. So there you go, the code. Well done, Alora. Thank you very much. So it's just strategists in caps. So if you do that, that'd be fantastic. If not, then just contact our office. Anyway, that's probably enough from me. I'm looking really exciting to see you. So Grant, will the session on the strategy day be available as recording? Absolutely. So what's happening is, just to give you a bit of background on the strategy day, you've probably been to ones before and they're pretty boring online. So this one we're doing a bit differently. We're doing it at the Change GPS boardroom. So we're setting it up and you'll be seeing myself, Tim, and also Michael, and it's as if you're going to be in a boardroom. I just find it's going to be a lot better teaching with slides and obviously a whiteboard there as well. My brother Chris, that'll all be streamed through Vimeo, and then we'll send you the Vimeo tags the day before, and then they'll be available straight after the event. So that's how quickly it is going to be. As I said, look, you're going to get so many hundreds and hundreds of thousands of dollars, even that one solution, that family allowance, where you can get clients potentially, if you set it up, not to have to pay 17% on that estate planning is beneficial. Anyway, that's enough for me. Sorry to go a bit over time, but it's pretty exciting stuff. Look, it's a great opportunity for you to get out and about and start upgrading your clients' discretionary trustees, because a lot of them are pretty ugly. It's Grant Abbott, signing off.